10 gun laws just changed after a Supreme Court ruling, and the new rules start this February 2026. Right now, not next year, not eventually. The changes are already in motion, and if you own a firearm in America, your rights just expanded in ways most people haven't even begun to understand. But here's what nobody's telling you. These protections only work if you actually know they exist. And right now, millions of gun owners are walking around completely unaware that the legal ground beneath their feet just shifted in a massive way. This isn't about politics. This isn't about taking sides. This is about 10 specific legal changes that affect how you own, carry, store, and defend yourself with a firearm. And if you don't know what changed, you're vulnerable. So let me walk you through exactly what happened, why it matters, and what you need to do about it right now. Because ignorance of the law has never protected anyone, and in February 2026, that's more true than ever. Let's start with the backbone of everything else that's about to unfold, because this first change completely rewrites how gun laws are judged in America. For years, for decades actually, the government had it easy when it came to restricting your Second Amendment rights. Courts allowed gun control measures to pass with minimal scrutiny. A vague justification here, an emotional appeal there, and suddenly another restriction became law. No real proof that the law was necessary, no evidence that it would actually work, just feelings, fears, and political pressure. That system is dead. The November ruling from the Supreme Court makes it absolutely clear that every single gun law in this country, federal or state, must now survive strict scrutiny. And if you don't understand what that means, let me break it down for you, because this is the single most important legal standard in American constitutional law. Strict scrutiny means the government can no longer just claim a gun law is a good idea and expect it to pass. They have to prove with actual evidence that they have a truly compelling governmental interest for limiting your constitutional rights. And it doesn't stop there. They also have to demonstrate that the law is narrowly tailored to achieve that interest, and that no less restrictive alternative exists that could accomplish the same goal. The burden of proof doesn't fall on gun owners anymore. It falls entirely on the government. And here's why that matters in practical terms. Thousands of gun laws across this country were passed under a much weaker standard. Laws that restricted magazine capacity, mandated waiting periods, banned certain cosmetic features on rifles, required permits for purchases. All of these were approved under frameworks that basically said, as long as the government has a rational reason, it's probably fine. That era is over. Now, every one of those laws is suddenly vulnerable to legal challenge. If a state can't prove with hard evidence that banning a 15-round magazine actually reduces crime in a meaningful way, that law can be struck down. If they can't show that a 7-day waiting period is the absolute minimum necessary restriction to achieve a compelling interest, it's gone. This is a total reset of how gun rights are protected in America, and it opens the door for real accountability. Laws that slid through on emotional arguments or political momentum are now on the chopping block, and gun owners finally have the legal firepower to fight back against restrictions that never should have passed in the first place. Now, let's talk about a change that could save you from financial ruin if you ever have to use your firearm to protect yourself or your family. Picture this scenario. Someone breaks into your home in the middle of the night. You're terrified, you grab your gun, you defend yourself, the intruder is stopped, and you survive. But then, just when you think the nightmare is over, you get hit with a lawsuit. Not from the state, not from law enforcement, from the person who attacked you or their family, and suddenly you're fighting for your home, your savings, your entire financial future, all because you refuse to become a victim. This isn't hypothetical fear-mongering. This has happened over and over again in America. A man in Ohio shot a burglar who was breaking into his house at 2 in the morning. No criminal charges were ever filed against him. Law enforcement looked at the case and said, "You defended yourself, you're clear." But the burglar's family sued him in civil court and won $400,000. Read that again? $400,000 paid to the family of a criminal who broke into his home. In California, a woman defended herself from an attacker in a parking lot. She fought back, she survived, and then she got slapped with a $1.2 million lawsuit for using excessive force. These cases expose a legal loophole that has existed for far too long, and it turned self-defense into a financial trap. You could do everything legally, survive the attack, avoid criminal charges, and still lose everything you own because some lawyer convinced a jury that you should have handled things differently. That nightmare just ended. The new ruling establishes absolute civil immunity for lawful self-defense involving firearms. If you use a gun to protect yourself and your use of force is legally justified, you are now completely shielded from civil lawsuits. Period. The attacker can't sue you. Their family can't sue you. Nobody can drag you into civil court unless they first prove in a criminal proceeding that what you did was unlawful. And unless they can meet that burden, no civil lawsuit can even begin. This is one of the most powerful legal protections gun owners have ever been given, and most people don't even know it exists yet. It means your home isn't up for grabs. Your retirement savings aren't at risk. Your kid's college fund isn't on the table just because you refuse to let someone hurt your family. For the first time, the law actually protects people who protect themselves. And speaking of legal protections, let's talk about police accountability, because this ruling just broke through one of the most controversial shields in American law enforcement. For decades, police officers who violated your constitutional rights were protected by something called qualified immunity. Even when they clearly overstepped, even when they broke the law, they were insulated from personal consequences. The doctrine basically said that unless there was already a court case with nearly identical facts proving that specific action was unconstitutional, the officer couldn't be held personally liable. It was a legal loophole that protected misconduct, and it applied to virtually every constitutional right, including the Second Amendment. That shield just shattered. The November ruling makes it explicitly clear that if a police officer violates your clearly established gun rights, they can now be held personally accountable. No more hiding behind qualified immunity. No more technicalities protecting bad behavior. If an officer unlawfully confiscates your legally owned firearm, if they arrest you for lawfully carrying when you've done nothing wrong, if they violate your Second Amendment rights in a way that any reasonable officer should have known was unconstitutional, they can be sued directly, and they can be forced to pay damages out of their own pocket. This isn't just theoretical legal language buried in a court opinion, it's already happening. In Virginia, a man was pulled over while lawfully carrying a firearm with a valid concealed carry permit. He did everything by the book. He disclosed that he was armed. He followed every instruction. He was calm, respectful, and compliant. And the officer still confiscated his gun without any legal justification. The man took it to court, and the judge didn't just side with him. The court awarded him $300,000 in damages personally charged to that officer. Not the department, not the city, the officer himself. That decision sends a message that has been needed for a long time. Violating constitutional rights comes with real consequences. For years, gun owners have been told, just comply, just follow orders, just let the officer do what they want and sort it out later. But compliance didn't protect people from having their rights trampled. It didn't stop illegal confiscations. It didn't prevent unlawful arrests. Now finally, there's a legal mechanism that holds officers accountable when they cross the line. And that accountability will make officers think twice before violating your rights. This isn't about hating cops. This is about demanding that everyone, including law enforcement, follows the law. Now let's expose one of the oldest and most manipulative tactics states have used to quietly ban guns without technically banning them. It's called the sensitive places loophole, and states like New York, California, and New Jersey have been exploiting it for years. Here's how it worked. After courts ruled that people have a constitutional right to carry firearms in public, these states couldn't just say, no, you can't carry. That would be too obvious, so instead, they created massive lists of places where guns were suddenly prohibited. Parks, libraries, grocery stores, parking lots, public sidewalks. Some states had lists with over 50 categories of so-called sensitive places. You were technically allowed to carry, you just couldn't carry anywhere that actually mattered. It was a backdoor ban disguised as reasonable regulation, and courts let it slide for years. That scam just got obliterated. The Supreme Court's ruling lays down a new, clear standard for what actually qualifies as a sensitive place, and it's no longer based on feelings, signs, or political preferences. It's based on objective security measures. A courthouse with metal detectors, armed security, and controlled entry? That's a legitimate sensitive place. A school with proper screening, law enforcement presence, and real security infrastructure? That counts. But a public park with nothing but a "no guns allowed" sign stuck on a post? That doesn't cut it anymore. A shopping mall that just decided to ban firearms with no actual security to enforce it? Not a sensitive place under the new standard. States are now being forced to scale back their lists dramatically. Some are cutting their so-called sensitive places by 80% or more because they can't meet the new legal threshold. And here's another critical change. If you're carrying legally and you walk into a private business that doesn't allow firearms, they can still ask you to leave. That's their right as a property owner. But here's what they can't do anymore. They can't have you arrested just for walking in while armed. The worst they can do is ask you to leave, and if you refuse, then they can pursue trespassing charges. But simply entering while legally armed is no longer a criminal act in itself. This change dismantles the quiet ban that states constructed, and it restores the actual meaning of the right to carry. Your rights aren't supposed to disappear the moment you step outside your front door. And now finally, the law reflects that reality. Let's talk about another game states have been playing for years, making it so difficult and time-consuming to get a carry permit that people just give up. This was never about denying your rights outright. That would be too blatant. This was about grinding you down with bureaucratic delays, endless paperwork, and complete silence from the licensing authority. You'd submit your application, pay your fees, complete your training, pass your background check, and then wait. 3 months? 6 months. In some parts of New York, people waited 18 months or longer. No updates, no timeline, no decision. Just an indefinite hold on your constitutional rights while your application sat in some bureaucrat's filing cabinet. And if you called to follow up, you'd get vague excuses or be told to just wait a little longer. That era of weaponized delays is finished. Under the new ruling, every state is now on a strict timeline. From the moment your concealed carry permit application is submitted, the state has exactly 60 days to approve or deny it. Not 60 business days. Not 60 days when we get around to it. 60 calendar days, and if they miss that deadline, your permit is automatically approved by default. They can't stall. They can't keep requesting additional documents unless there's a specific, clearly defined legal issue that justifies it. They can't pause the clock. And if they deny your application, they have to provide a full written explanation with actual legal reasons, not just a vague form letter saying application denied. The results are already showing up. Some states that previously took half a year to process permits have approved more applications in the last 3 weeks than they did in the previous 6 months combined. The delays are done. The games are over. If you qualify for a permit, you get it on time. And if the state tries to drag its feet, they're in violation of a federal court order. Here's something that should have never been controversial but somehow became a battleground: how you store your own firearm in your own home. Some states passed storage laws that sounded reasonable on the surface but were clearly designed to make your gun completely useless in an emergency. In Massachusetts, the law required that ammunition be locked in a container separate from your firearm. In California, you had to store your ammunition in a completely different room from where your gun was kept. One county in Illinois went even further and required firearms and ammunition to be stored on different floors of your home. Now think about what that actually means in a real-world scenario. It's 3 in the morning, you hear glass breaking, you hear footsteps, someone is inside your house. You grab your gun, but it's unloaded. You run to another room in the dark, fumbling for keys, trying to unlock a second container to get your ammunition. You're loading your gun while an intruder is somewhere in your home, and you're just praying they give you enough time to finish before they find you or your family. It's not just unrealistic, it's dangerous. And now, it's unconstitutional. The ruling makes it absolutely clear that any storage law preventing immediate access to your firearm in an emergency violates the Second Amendment. You now have the explicit right to store your firearms and ammunition together in whatever configuration makes sense for your home, your family, and your security needs. The government doesn't get to dictate what's safe for you in your own house. That decision belongs to you, and now the law finally backs that up. If you want to keep a loaded firearm in a quick access safe next to your bed, that's your right. If you have young children and you choose to store things separately, that's also your right. The point is that it's your choice, not the state's. For years, gun owners were told there was no national gun registry in America. And legally speaking, that's exactly how it's supposed to be. Since 1986, federal law has explicitly banned the government from creating any system that connects specific firearms to specific individuals. It's a protection that was built into the law precisely because Americans understood the danger of the government having a list of who owns what. But behind the scenes, several states found clever workarounds, and now it's all coming to light in a way that's absolutely stunning. Take California, for example. Their so-called dealer record of sale system quietly stored detailed information on every handgun purchase dating back to 1996. 20 million records, all of them linking names, addresses, and personal details to specific firearms. In Hawaii, the law required every single gun to be registered with local police, including the make, model, serial number, and the owner's full personal information. These weren't voluntary programs, they were mandatory systems that tracked law-abiding gun owners like criminals, and they existed in direct violation of federal law. The November ruling didn't just acknowledge these systems, it ordered them destroyed. The court ruled that any state-run database tracking individual gun owners or their firearms is a direct violation of federal statute, and these registries must be completely dismantled within 180 days. No exceptions, no extensions. And states are required to notify every affected gun owner in writing that their information has been permanently deleted. Some states are already trying to push back, claiming they need these systems for law enforcement purposes or public safety. The court didn't leave room for those arguments. Non-compliance means contempt of court charges and daily fines until every record is gone. This is the first real enforcement of the registry ban we've seen in decades, and it's a massive victory for both privacy and gun rights. Your personal information, your firearms, your private property, none of that belongs in a government database. And now, finally, the law is being enforced the way it was always supposed to be. Let's talk about how the ATF has been terrorizing law-abiding gun dealers over paperwork errors. For years, the Bureau of Alcohol, Tobacco, Firearms, and Explosives used minor technical violations to revoke federal firearms licenses and shut down businesses. These weren't criminal acts. These weren't safety violations. They were paperwork mistakes. A wrong date, a transposed number, using the wrong color ink, and the penalties were devastating. One gun store in Pennsylvania lost its entire license because the owner accidentally wrote 2022 instead of 2023 on a single form. One form, one date, license gone, business destroyed. In Texas, a dealer had his federal firearms license revoked because he used blue ink instead of black on a transfer document. The information was correct. The background check was completed. Everything was done properly except for the color of the pen, and that was enough for the ATF to shut him down permanently. These weren't isolated incidents. This was a pattern. The ATF was weaponizing administrative errors to eliminate gun dealers they didn't like, and they were doing it under the guise of enforcement and regulation. It was a backdoor method of gun control that targeted small businesses and home-based FFL holders who couldn't afford legal battles. That abuse just ended. The court's ruling makes it explicitly clear that the ATF can no longer strip someone of their federal firearms license over administrative mistakes. They must prove an actual criminal violation or a serious pattern of negligent behavior before revoking a license. And if errors are found, the agency is now required to issue a written warning and give the dealer a fair opportunity to correct the problem before taking any further action. This levels the playing field for small gun shops across America. It stops the government from using regulations as weapons, and it restores basic fairness to a system that had become deeply corrupt. Now, let's talk about something gun owners have wanted for years: the ability to travel across state lines without leaving their rights behind. For decades, concealed carry permit holders have been trapped in a confusing, constantly changing maze of state-by-state rules. You could have a valid permit in Georgia, but the second you crossed into Florida, it meant nothing unless Florida happened to have a reciprocity agreement with Georgia. And those agreements changed all the time. One year your permit was recognized, the next year it wasn't. Unless you memorized complex reciprocity maps and checked them constantly, you were at risk of being arrested just for crossing a state border with your legally carried firearm. Sometimes that border was 20 minutes down the road. This November's ruling establishes a national baseline for concealed carry recognition, and it's a game changer. If your concealed carry permit is valid in your home state, it is now legally recognized in at least 42 other states. No additional paperwork, no extra fees, no separate applications. Your Texas permit now works in New Mexico. Your Arizona permit travels with you across most of the country, and states can't add extra restrictions or demand additional requirements just because you're from out of state. If your permit is valid at home, it's valid on the road. Police departments in states that previously refused to honor out-of-state permits are already undergoing retraining on the new standard. This gives gun owners something they've been fighting for: the freedom to travel across America without losing their constitutional rights at arbitrary borders. Your Second Amendment doesn't stop at your state line, and now, finally, the law reflects that reality. And here's the final change, and in many ways, it's the most important one because it deals with the absolute worst nightmare scenario for any gun owner: using your firearm to defend your home and then being treated like a criminal for surviving. This has happened too many times. Homeowners who clearly acted in self-defense still found themselves arrested, charged, and dragged through the legal system for months or even years. One man faced aggravated assault charges after shooting a burglar who was armed with a crowbar and breaking into his house. He had to spend 2 years and tens of thousands of dollars in legal fees proving that he did the right thing. A woman in Maryland shot her abusive ex-boyfriend after he kicked in her door in direct violation of a restraining order. She survived. He didn't. And she still spent 8 months in jail before the case was finally dropped. Think about the psychological torture of that. You survive the most terrifying moment of your life. You protect yourself or your family from someone who intended to harm you. And then the system punishes you for it. You're arrested. You're jailed. You're treated like the criminal while lawyers and prosecutors second-guess every decision you made in a split-second life-or-death situation. This ruling finally brings the law in line with basic common sense and human decency. If you use a firearm to defend yourself inside your home or on your property, the burden of proof is now entirely on the prosecution, not on you. Prosecutors must prove beyond a reasonable doubt that your actions were not justified self-defense. And unless they can meet that burden, the case doesn't move forward. This completely flips the equation. You are no longer forced to prove you were right. They have to prove you were wrong, and if they can't do that, you walk free. This is one of the most powerful protections ever added to castle doctrine laws in American history. It means that in the most terrifying moments of your life, when everything is chaos and fear and adrenaline, the law will actually be on your side. You won't have to spend years justifying why you chose to live. These 10 changes represent the biggest shift in gun rights we've seen in decades. They affect how you own, carry, store, and defend yourself. And understanding them could be the difference between staying legally protected or ending up in court fighting for your freedom and your finances. Don't keep this information to yourself. Share it with every gun owner you know, because these rights only protect you when you actually understand them. Knowledge is your first line of defense. The laws have changed, your rights have expanded. Now it's up to you to know what they are and how to use them. February 2026 is here. The rules are different, and ignorance won't protect anyone.